Yes.
My Lord, just before we rose for the short adjournment, I was referring to the examples set out in paragraph 61 of our grounds of appeal. Could I, before going into those examples, just bring together where we've got to? In the first example, we've got the MP, the subject of the allegedly dishonest statements, making his or her claim, and it does not, on its face, involve the exercise of his or her real or essential functions or his or her core activities, if that's the approach. But what it involves is an engagement with the proceedings of the House. And the reason I wanted to introduce that is to go to paragraph 82 of the judgment of the Court of Appeal. And this is again the reference to ordinary crimes. And in paragraph 82, after the reference to ordinary crimes on the fifth or sixth line, even stretching language to its limits, we are unable to envisage how dishonest claims by members of Parliament for their expenses or allowances begin to involve the legislative or core functions of the relevant House or the proper performance of their important public duties. Now, I just wanted to isolate out, and perhaps should have done earlier, that Article 9 only works if you contemplate that there is a criminal act, using the criminal example. So the fact that the claims are dishonest doesn't take them out of the functions of the House or the functions of the MP. So,
where do we find Article 9, just most conveniently set out?
So tab 1 of volume 1. And it's the 9th article on page 5 of 9, under the heading Freedom of Speech, that the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or place out of Parliament. Right. So it's page 5 of 9, my Lord.
5 of 9.
At the very top of the page.
Thank you.
Yes, top of the page.
That's 9.
It's the 9th article of the Bill of Rights. I hope. There's supposed to be a lot more. But that's the one known as Article 9.
Can I see if I grasp the point you're making? You're in effect asking us to look at that sentence and take out the word dishonest and ask whether it...
I'm sorry, I put it away too far.
I'm so sorry. This is paragraph 82 in the Court of Appeal.
Yes, sorry.
You're saying, well, you can't, as it were, distinguish between claims that are honest or dishonest.
Exactly.
They all stand or fall together.
Yes.
And that by putting in the word dishonest, they're creating, as it were, putting up an Aunt Sally which ought not to be there. Is that?
Well, it's the theme that goes through, including ordinary crime, that they've now got to the position, suggesting, I'm not sure that they're actually saying this, but they're suggesting that the fact that it's a allegedly dishonest claim takes it outside the privilege, because you can't have a dishonest claim being part of the legislative or core functions of the relevant House or the proper performance of their important public duties. Well, if that's right, then Article 9 loses its force, because it would only cover honest claims by members, and that can't sensibly be right, otherwise you wouldn't need the immunity.
Article 9 assumes that there would otherwise be some proceeding in some court,
Exactly.
calling in question or impeaching.
Either a defamation claim or a civil law claim or a criminal law claim. And that's why we chose as our first example the House itself, which we'd say is no different from the register of members' interest, where the member stands up and says, I have an interest to claim, or says at the end of the day's sitting, I have an allowance to claim. Sorry, I have an interest to declare, or I now have an allowance to claim, and it's all tied in with that. And that's why we tried to do, and still try to do with this example, is just in a logical and principled way start with the original example and then work through the variations just to see where we get to in terms of where do the proceedings stop. And we are assuming that the original example, the answer we proffer of yes is the correct answer. If, however, your Lordship, lady, you conclude that it doesn't apply to the first example, then we are in difficult territory when it comes to the variations. Your Lordships may well have narrowed the privilege down to the way it's being described in those words in paragraph 82. But if the answer to the first one is yes, then we say there can be no sensible distinction when considering variation 1. The House resolves that all applications for repayment will be handled by a committee, calling it, doesn't matter, the Estimate or Expenses Committee, but it requires a personal oral application. So that's the only difference. We've moved from the chamber to a committee, and at the end perhaps he presents a bogus receipt or makes an oral application. Does parliamentary privilege apply? Yes, for exactly the same reason that it is in 1. So if we are correct on variation number 1, and we submit that we are, where is the logical or principled distinction to allow the correct answer to variation number 2 to be no? Variation number 2, same as variation number 1. All applications must now be made in writing. It's been going jolly well for a few years. Prescribing an application form, let's call it an ACA2. Does parliamentary privilege continue to apply? The Crown would perhaps at this point say no, but is that on the basis that it's now in writing? Well, that can't be right. We say that the answer must be the same as variation number 1. Yes, and there's no principal distinction. But if variation number 2 is correctly answered, then variation number 3 is, we submit, not materially different. It hasn't moved from being not proceedings in Parliament to proceedings in Parliament to not proceedings. The same as variation number 2, save that the Members' Expense Committee, with the approval of the House, delegates the management of the approval function to a subcommittee or to a fees office of the House. The applicant submits that there is no difference in substance principle, and parliamentary privilege continues to apply.
What if it had what if the House had set up a scheme whereby members could be reimbursed from their expenses by attending at the local post office or branch of the Hong Kong and Shanghai Bank?
It may be at that point, your Lordship has identified the line when you cross from proceedings in the House to something beyond. And that's why the new act is of interest, which is the Parliamentary Standards Act, which is in Volume 1, Tab 6, which has itself created a body which is independent of Parliament. So it's now, we won't call it the Hong Kong and Shanghai Bank, it's to be called IPSA, the Independent Parliamentary Standards Authority. And your Lordship also postulates an example where it will be purely mechanistic. You just go along and collect your cheque from the post office, whereas the fees office acts as delegate to the House, and any queries or questions are referred back up the line through the Members' Estimate Committee and then eventually to the full House.
Well, if one thinks about the post office example for a moment, one might be thinking of a system in which the MP put in a claim to some body within the House, which then authorised the payment of the claim, gave him a chit which he took along to the post office to cash, rather than the fees office handling the cash. am I right in thinking that you would say that the process of putting in the claim and the Fees Office handling the claim and authorising the claim was a proceeding in Parliament, but if the MP, having been given the chit, then forged it or forged a chit and took it to the Post Office, that would not be a proceeding in Parliament?
Unless I can make that link between what's going on in the Post Office and Parliament, no, it's not part of our case that it would be included. That's why the 2009 Act is really quite interesting, not very interesting, but quite interesting, and it sets up this independent body and then creates an offence. So what you have is a body corporate known as the Independent Parliamentary Standards Authority. It prepares a scheme, it deals with salaries and expenses, and you see from page 3 of the photocopy, that sets out the MP's allowances scheme. And under, I think it's section
10.
Yes, you start, my lord, with section 1. Nothing in this Act shall be construed by any court in the United Kingdom as affecting Article 9 of the Bill of Rights. So then we get to section 10.
Where is that? That's
Section 1.
Section 1.
next.
Also, section 2, nothing in this Act shall affect the House of Lords. So we're only dealing with the House of Commons. And section 10, as Lord Brown notes, is the offence. The offence of providing false or misleading information for allowances claims. A member of the House of Commons commits an offence if the member makes a claim under the MP's allowances scheme, which itself is defined, and provides information for the purposes of the claim that the member knows to be false or misleading in a material offence, he commits an offence. And the MP's allowances scheme, if you look at paragraph 12, is defined. The MP's allowances scheme has the meaning given by section 5.2, and 5.2 tells you that the allowances scheme is the scheme prepared under this section. So it's the IPSA scheme. It doesn't cover the existing arrangements between MPs and the House. So here you do have Parliament creating this break away from Parliament, so that Parliament now has its own, it created an independent scheme and then creates a criminal offence to go with it.
But the expenses that the MP receives under the new scheme, do you say that they're still associated with the discharge of parliamentary functions?
Well, yes, they still have that connection, my lord, yes.
And I suppose you could say that IPSA is a delegate of Parliament for this purpose. I suppose you could say that having regard to Section 1, it hasn't achieved the, on your argument, perhaps it hasn't achieved the, what you intend, because the whole Act is subject to Section 1, so it all depends what the answer to the question before us is.
My lord, you'd still end up with asking the question, it's not just whether the MP is engaged in the better performance of his duties, the question from my Lord Carr, swinging round to my right. It's also a question of identifying still for Article 9 whether we are looking at Parliament or proceedings in Parliament. And the definition of the scheme under 5.2 could be argued to read, I don't need to deal with it, that it is only dealing with an IPSA scheme. And the IPSA scheme, IPSA is a body corporate which is not a part of the proceedings of Parliament because it's described as an independent corporate body.
Yes, that's what I was wondering. If it hadn't been called independent, and if there hadn't been express provision for criminal sanctions, would it then be questionable whether this body had made a difference?
It has to be, first of all, it has to be independent. We say it's unnecessary for us to go further, that it doesn't make a difference. what would then arise is an interesting question as to whether its decisions are subject to judicial review. Can I leave that for another time and another place? Because there are arguments as to whether or not this body itself is a public body susceptible to judicial review. And an interesting question then arises as to whether or not it falls within proceedings in Parliament for the purposes of Section 6.6 of the Criminal Rights Act. We say no because of the word independent that separates it out from Parliament. And also I pointed out the definition in Section 5.2. Well, I've slightly gone off as a tangent on the Act. The Post Office led to the Hong Kong and Shanghai Bank and to its side. My apologies. So I was then going to look at, I was going through the variations, and I got to variation 3, and variation 3 we say is not in principle different from variation number 2. It's the same as variation 2, save that the management function of the management of the approvals has been delegated to a subcommittee or to a fees office. That we say there's no difference in substance, and you have the submission. The Court of Appeal said in paragraph 74 that it was unnecessary to address these examples because the question is whether privilege attaches to the particular circumstances in which a statement is made and whether those circumstances attract privilege necessary for the proper functioning of Parliament. Again, with greatest respect to them, those circumstances, can we submit, only be understood, or properly be understood, by examining where they fit into the parliamentary scheme of things, using the examples or similar examples to run through the analysis and find out where one arrives. And it is the isolation of the fees office from Parliament that may have led the Court of Appeal to conclude, in the paragraph I referred to earlier, paragraph 77, that these former MPs are accused of defrauding the fees office by submitting a false claim for expenses. And that's the phrase used at the end of paragraph 77. On any sensible analysis, the MP is submitting, even if his claim is dishonest, he is submitting it to Parliament, or perhaps more correctly, to the relevant committee acting on behalf of the House. And we submit, when correctly analysed, that the submission of the form and its supporting documents is a statement to the House, even if made through and handled by the House's delegate. On no sensible basis can it be said that the MPs are accused of defrauding the fees office or merely making a statement to the fees office as if that's all we're talking about. And that is to misunderstand the structure of Parliament and the role of the fees office, or the Department of Finance and Administration, which itself is an emanation of the members' estimate committee. So it's really back to the Legg report. Sir Thomas Legg is not to be distinguished from his 54 helpers. They are part of the same review, although it has as its title Sir Thomas Legg, and he's responsible for the recommendations. We draw this together in our grounds of appeal at paragraph 58. If your Lordships, my lady, wouldn't mind if I just go to that, because this became really part of the argument at the first instance level. If it is accepted, as the appellants say it ought to be for the reasons given above, that the expenses system is part and parcel of proceedings in Parliament within Article 9, it is submitted that there is no proper basis for excluding from such proceedings the centrally important claims forms submitted by the MPs to the Fees Office and the process there of approval or rejection of the claims made. To do such would be to impeach or impugn the workings of a scheme entirely orchestrated by Parliament, which is essential to and intimately connected with the workings of Parliament and the executive decisions made pursuant to such a scheme, thereby offending Article 9. And then we say this: to use the example identified by Mr. Justice Saunders, there is no sensible distinction between the slot machine, that's the ACA scheme, and the coin, the claim form, a distinction he sought to highlight, we submit incorrectly, in paragraph 22.1 of his judgment.
Mr. Penning, as a matter of interest, I mean, clearly one wouldn't advocate an originalist approach in this jurisdiction, but if we were looking at the Bill of Rights in an American context, I no doubt we would be looking at what the language meant in 1689. We've been given remarkably little background to what it in fact meant in 1689. I assume that Sir John Eliot's case is a major part of the background. Is it possible to be more specific? Because on the face of it, it's talking about freedom of speech, that's Sir John Eliot's case. Debates, that's Sir John Eliot's case again. Or proceedings in Parliament. Now, you're trying to give a pretty wide, or as wide a meaning as you can to the word proceedings in Parliament, but I wonder whether any case approaching the present would have been in mind in 1689.
No. It wouldn't have been in mind for a whole series of reasons. One of them, they did not have an allowance scheme. They didn't have any schemes which were similar. The origin, could I preface this, my Lord? In one of the judgments, I'll remember in a moment, I think it's Lord Brown Wilkinson in Treble, he says there's a danger of being tied to the historical evolution of Article 9, because Article 9 is still with us in 2010 and the world has changed. So the reason for, or part of the reason for the introduction of Article 9 was that Sir John Eliot and his colleagues were tried and imprisoned on the basis of two offences. One is uttering sedition, and then at the same time stopping the Speaker of the House from adjourning proceedings by bringing his gavel down. And he was held to his chair and prevented from doing that. They went to prisons, and Sir John died in prison. That then led to the what happened in 1666, when the House of Lords and the House of Commons sitting together said that was not right, for putting it bluntly. And the debate from the historical papers such as Holdsworth, indeed Mr. Justice Stephen in Bradlaugh and Gossett, is what happened in that period is pretty unclear. We probably still have Eliot's case in the bundle, and most of it, unfortunately, is in Latin. But what it shows is that the House of Lords and the House of Commons, post in the Reformation, were saying either two things were going wrong there. Either you couldn't have put a freedom of speech example in the same charge as an assault, and you polluted the waters by doing that, or there should have been no trial at all in relation to what was done in Parliament, so done and said. That led to what became a part of the Bill of Rights. So it's founded in the ability of a member of the House to stand up in the House and speak his or her mind without fear or fear of arrest. But I think it's Preble, I'll find the reference, where there was a criticism of various cases and a reference back to the Church of Scientology case that I mentioned earlier, saying you still have to examine with care what proceedings in the House mean, and we have moved on. So we have now committees, we have now delegates of committees, but to focus purely on what was happening in the 17th century, we would say is an error. And also, as with any statute, even the most important constitutional statutes, they are always speaking. Well, that's probably a rant rather than a response, for which I apologise. But I'll find you the Preble reference.
Supposing that someone repealed Article 9, what would the position then be as regards privileges of Parliament?
They would still be there Article 9 is said to be a statutory enactment of privileges going back to at least the 1520s. You see, learned friend Mr. Fitzgerald may be more versed in this, that Article 9 is a statutory emphasis of an existing range of privileges. If Article 9 was repealed, all of the old privileges would be there, and we expect would be not dissimilar when fully examined to what you find in Article 9.
It would be up to the courts to decide what the extent of those privileges were.
Certainly.
Ultimate.
We accept that it's the task of this court to decide what is meant by proceedings in Parliament and the reach of those words, certainly. It's then up for Parliament, assisted by your decision, as to whether or not they stay with your decision and don't amend the Act. If they don't amend the Act, then they will decide whether or not, in a given set of circumstances, the facts fall within it. My Lord, just to, I was trying to remember Preble, it's volume 2, tab 20 rings a bell, but it could be tab 19. Sadly, it is tab 20. This is the Privy Council. It's the judgment of the Privy Council was delivered by Lord Brown Wilkinson, and there is a long examination of Article 9 on page 332, and there's reference to Blackstone in between E and F on page 332, having discussed Burton, Abbott, Bradlaugh and Gossett, Picken and British Railways, and Pepper and Hart. As Blackstone said in his commentaries, the whole of the law and custom of Parliament has its origin, not its original, its origin from this one maxim, that whatever matter arises concerning either House of Parliament ought to be examined, discussed and adjudged in that House to which it relates and not elsewhere. And read on. But the reference to the narrow construction, yes, it's on page 333. There's reference to the Church of Scientology case at G, and then this. Finally, Mr. Justice Hunt based himself on a narrow construction of Article 9, derived from the historical context in which it was originally enacted. He correctly identified the mischief sought to be remedied in 1689 as being, inter alia, the assertion by the King's Court of a right to hold a member of Parliament criminally or legally liable for what he had done or said in Parliament. From this he deduced the principle that Article 9 only applies to cases in which a court is being asked to expose the maker of the statement to legal liability for what he has said in Parliament. This view discounts the basic concept underlying Article 9, the need to ensure, so far as possible, that a member of the legislature and witnesses before committees of the House can speak freely without fear that what they say will later be held against them in the courts. Important public interest protected by such privilege is to ensure that the member or witnesses at the time he speaks, emphasised, is not inhibited from stating fully and freely what he has to say. If there were any exceptions which permitted his statements to be questioned subsequently, at the time when he speaks in Parliament he would not know whether or not there would subsequently be a challenge to what he is saying. Therefore, he would not have the confidence the privilege is designed to protect. And then the next paragraph explains, moreover, to allow it to be suggested in cross-examination or submission that a member or witness was lying to the House could lead to exactly that conflict between the courts and Parliament, which the wider privilege of non-intervention is designed to avoid. Misleading the House is a contempt of the House punishable by the House. If the court were also to be permitted to decide whether or not a member or witness has misled the House, there would be a serious risk of conflicting decisions. So, well, yes, we do have to bear in mind what was enacted and why it was enacted. At the end of the day, we have to look at proceedings in Parliament in 2010, 2000.
Now, where does the money come from?
Public purse.
How's it done?
It's an estimate.
It's in the
Yes, it's the, again,
in the Appropriation Act.
I'll check in Erskine May. The language is, an estimate is given for allowances and expenses, which comes from the public purse, obviously.
They're claimed retrospectively. Were they at this time?
Yes, in the Green Book, it tells you that I think all claims are retrospective under the allowance scheme, but some expenses can be claimed prospectively. But these were all retrospective claims.
Is there a slight difference between the Court of Appeal and what was said in Preble. Preble at page 334 in the passage we just read suggests that there should be an overlap between parliamentary contempt proceedings and proceedings in court. Tends to suggest at C&D that the two abut rather than overlap, whereas the Court of Appeal appears to have accepted in paragraph 47, for example, that there were situations where both Parliament and courts can assert jurisdiction.
Yes, there is a tension between those two paragraphs, particularly if one goes back to the beginning of the speech in Preble at page 328. That makes it as clear a statement as one can get, that Article 9 precludes any court from impeaching or questioning the freedom of speech in debates or proceedings in Parliament, prevents the court from entertaining any action against a member of the legislature which seeks to make him legally liable, whether in criminal or civil law, for acts done or things said by him in Parliament. And the example, of course, because this is Preble, is libel. There could be some overlap with Parliament to this extent. Take the example of the MP we touched on earlier from Wesley, who behaves dishonourably by disregarding an order of the court. We assume for the moment that this is a situation where the criminal law is rightly engaged. So you have the criminal process. It doesn't mean that the Parliament itself can't look at that conduct and see it to be in contempt or behaving contrary to the principles of the House. What is far more difficult is when the allegation falls within proceedings and the privilege is claimed. At that point, it's the exclusive jurisdiction of Parliament, which may or may not choose to act. But there are other examples where the privilege may be, the House may choose not to act, and Mr. Fitzgerald will deal with that. Well, that's all I wanted to say on Preble. Well, I'd got to the position of reading out to you the court paragraph 58 of our grounds of appeal. That's the slot machine and the coin example, which we say there's no sensible distinction. If the slot machine is proceedings in Parliament, then the document going in is just as much a part of those proceedings as the eventual decision. So we submit that the creation, the implementation, important word when we get to the Joint Committee in 99, and the operation of the MP's allowance scheme form part of the internal proceedings of Parliament and cannot be distinguished from, for example, the leg review or other similar proceedings in Parliament, even if not part of parliamentary debate or the primary meaning of proceedings as mentioned in Erskine May. That leaves me my only other topic, which is very short, and that's the Joint Committee on Parliamentary Privilege. All sides, sounds wrong, the appellants, the Crown and the courts below, but there has been repeated reference to the Joint Committee on Parliamentary Privilege. This was a report made in 1999. It's at volume 5, tab 49. We have relied on this report. For example, as I said earlier, we rely on paragraph 38. Well, I should show you the constitution of the report. It's clearly a very respected membership, both in the House of Lords and the House of Commons, including Lord Nichols of Birkenhead. The contents of the report show the wide area of coverage, and the executive summary brings it all together. But could I just show you the paragraph I referred to and relied on earlier, which is paragraph 38 on page 17. 17 is where the Article 9 of the Bill of Rights is being discussed, and legal immunity is then referred to. Article 9 protects the member, this is fourth line down, fifth line, who knows what he is saying is untrue as much as the member who acts honestly and responsibly, nor is the protection confined to members. Article 9 applies to officers of the Parliament and non-members who participate in proceedings in Parliament, such as witnesses giving evidence to a committee of one of the Houses. In more precise legal language, it protects a person from legal liability for words spoken or things done in the course of, or for the purpose of, or incidental to, any proceedings in Parliament. So we rely on that as a proper description of the content of Article 9. And paragraph 83, without going through this report in great detail, there's also reference to the general principle, and it's a proposal in this report that the House should have power to waive Article 9, but only where this would not expose the speaker of the words or the doer of the acts to legal liability. And then there are various sections through what follows. At 97 to 101, it deals in particular with proceedings in Parliament. But could I just add these words of caution that one has to keep in mind when reading this report that it is part descriptive, part expressions of opinion, and part recommendations for the future. And this is clear from the executive summary, but sometimes that those three aspects of the report are lost. Now, although it was debated in 1999, so far as we are aware, no action was taken, no consequential legislation was enacted, even though there was a strong recommendation that there should be a statutory definition of what is meant by proceedings in Parliament. Paragraph 110 refers to the core activities of Parliament, unless a pressing need is shown for an extension. But what was being examined there was whether or not the privilege in Article 9 should be extended to cover correspondence between members and ministers. And they decided...
You don't get much support in their analysis of proceedings, do you? I mean, for your definition of proceedings.
I only get active support when I come to their suggested statutory definition relying on the Australian definition. But I don't not specifically, no. But what I do get, my Lord, is reference to the Register of Members' Interests. And we can pick that up at paragraph 119. We say that there is no in-principle distinction between the allowances scheme and the registration of members' interests. 119, another area of uncertainty concerns registration of members' interests. Both houses have procedures for registration of members' personal peculiar interests. These procedures are part of the machinery brought into being by each house for the better conduct of its business. They are under the sole control of each house and not subject to supervision by courts of law. We consider these procedures also qualify, or should qualify, for the protection afforded by Article 9 to proceedings in Parliament.
I think one of the points that Mr. Panic makes in his argument is that it's very difficult to see what comparable, what equivalent criminal offence could be committed in respect of the members' interest register, as in our case.
Well, we've given you two, my Lord, in the list of criminal charges, not the offence itself of failing to register, that wouldn't be the offence, but the failing to disclose the interest when making the statement in the House may be an offence under the relevant section of the company's legislation. I've forgotten the section.
Sorry, I'm looking at the piece of paper.
Yes, it's the list of offences.
I know, page 2.
Lord, you're ahead of me. Page 2, the offences under 1 to 3 of the 4 of the Fraud Act, the airport example. And possibly...
Well, I mean, sorry, what is the fraud consisting of what he's actually then doing in the way of supporting the project? Or is it in... I mean, you don't stop the fraud as at the failure to record the interest in his statement of interest, do you?
No, my Lord, I can't find you an offence of failing to register. All we can do in the example of under the Fraud Act or Section 397 of the Financial Service and Markets Act is refer to a misleading or false statement that include the failure to register. That's all, my Lord. And that's because the nature of the beast is different. The registration of interest is dealing simply with that rather than a claim for money. Well, what I was seeking to show you in 119 is only that the register of members' interests is identified by this committee as an area where Article 9 should run. And we say, and say again, there's no distinction. And it's developed in greater detail, including complaints against members over the next 2 pages. And you then get this leads to the suggested statutory definition, which is advanced as a recommendation, but is never taken to fruition. So,
how do we know that it's not subject to supervision by the courts? In paragraph 119.
I'm sorry, my Lord.
How do we know that the register of members' interests is not subject to supervision by the courts of law? How does the committee know that?
I see, my Lord. That's a very good question.
It depends whether it is qualify or should qualify, which applies.
Well, it's indeed a very good question, because the touchstone for identification is that this is not subject to supervision by courts of law, which itself is based on the argument that it is part of the proceedings of Parliament. So, Lord, you may have identified a circularity in paragraph 119 that I haven't spotted. But the reason that there is no judicial review of the register of members' interests, no judicial review of the decision not to pay resettlement grants to the former MPs, no judicial review of the decision of the Fees Office so far, is because they are part of the proceedings of Parliament. If this court's conclusion is that they are not, then there may be adverse consequences for my clients, but there may also be opportunities for judicial review challenges to the decisions by the register, more importantly by the money-related decisions in allowances, expenses and claims.
Well, there have been some cases, haven't there, where people have been criticised for not registering interests, and they've been brought, some kind of quasi-disciplinary proceedings been brought by the House. I'm thinking of the House of Lords, actually.
Certainly. They brought, failing to register, in the examples I've given you, that was what I was trying to flag up. They may be criminal offences related to this, but failing to register is a breach of a contempt of Parliament, a breach of the requirements of standards and privileges. So, yes, you will find examples and then the publicity given to those examples, but what you don't find is a judicial review of the decision of the Register of Members' Interests in the same way in the Al Fayed case and the Commissioner for Standards and Privileges that you don't find a review of the decision of the Commissioner, because that was protected by parliamentary privilege. Well, could I'm taking rather longer than I expected. I do apologise.
Can I just ask, in which cases has Article 9 been applied, which can't, in a very broad sense, be called freedom of speech cases?
Well, can we think of the answer, but we suspect that they are all forms of freedom of speech, and we say this is as well. It might be tied up as a dishonesty claim, but it's all linked to freedom of speech. McGuinness is the nearest one I can remember, Lord Kerr giving the judgment there. That was an application by Mr. McGuinness for a reasoned decision from the Speaker as to why he couldn't attend Parliament, and that was held to be part of the proceedings in Parliament. But it wasn't to do with freedom of speech, it was merely proceedings in Parliament. But I have no parallel to this case, because as I said earlier, this is the first time since whenever that a Parliament, that an MP, serving member of Parliament, has been prosecuted in relation to his or her relationship with the House. So, my Lord, the answer is I don't know of any specific examples. My Lord, if I could leave the register of members' interests, it's really...
Well, just one last point on that. Paragraph 129 doesn't obviously include the form you filled in, does it? Your clients filled in.
I'm sorry, no, I didn't hear.
The categories of proceeding in either, certainly in paragraph 129, 1 or 2, with the possible exception of little e, but even then, doesn't obviously include the kind of form that your clients have filled in order to obtain their expenses back.
But the only candidate would be 1292B.
Yes.
The presentation or submission of a document to a House or a committee or an officer appointed by the House to receive it once the document is accepted. And the Fees Office is an office or an officer appointed by the House to receive Form ACA2. ACA2 was a form created by Parliament and appears as a standard document in the Green Book. So that's the candidate sub-paragraph.
Yeah.
And, Lord, the other...
Sorry, what does it mean once the document's accepted? I mean, if they'd said, terribly sorry, we don't think this is an honest claim, and rejected, can they then be... Is that all right? That's attempted false accounting or something?
I don't know that. Simple answer. I don't know what would happen in terms of the legal analysis in crime terms. It wouldn't affect the analysis of whether or not it's a document being submitted as part of proceedings. But, Lord, at the moment, all we have is a suggested enactment of a definition which was never enacted. So if it was to be enacted, that very same question would be the subject of debate in Parliament before it decided whether to include or exclude the last 5 words.
Well, in the case of the ACA2, once accepted, one assumes the money is then paid out as requested, but that money is taken from funds which are administered on behalf of the House, which one can trace back to some kind of budgetary proposal by the House to the Treasury and so on and so forth. So it's drawing from central funds in the name of the House to make good the claim.
Certainly.
That would be the link, I suppose.
Yes, Lord.
But the document has to be geared to the transaction of the business of the House of Parliament. If you look, it's a reference back to the first proposed subsection. And the question ultimately must be, is the submission of a claim geared to transacting the business of the House of Parliament?
Well, if you're applying the words of the enactment definition that was never accepted, yes, one would have to examine and then construe a suggested section that was never enacted. But what one is looking for still is something which is either part of the proceedings in Parliament or so closely connected to it that it should be included within the privilege. And the main point that we have been emphasising is that the creation, management, regulation of the allowances scheme itself is part of the proceedings in Parliament. So you start with that, and as with the Register of Members' Interests, as with the Legg report or the Legg review, and the documents then fall as part of the review, the proceedings in Parliament. You don't ask whether the document itself is proceedings in Parliament.
I think they've taken that bit. D looks as though it's come from Australia. If one looks,
It's the Australian section
Australia.
17, wasn't
yes,
it, of the Australian?
Appendix B.
It's the green book in the core volume. Well, this is the appendix to the core volume, which explains
Page?
page 105 in the appendix. It's really, perhaps you picked this up already. Members of Parliament are provided with financial support in the form of allowances to enable them to work effectively in Parliament and in their constituencies. Parliamentary allowances are designed to ensure that members are reimbursed for costs properly incurred in the performance of their duties, etc. Lord, the other part of this report, which is relied on by the Crown and is of interest, is when one comes to a chapter, page 62, there's a heading, Control by Parliament over its affairs. And there's a distinction that I wanted to highlight at this point between the payment of allowances by the House to its members, particularly salaries, pensions, allowances, particularly allowances, and where third parties are involved. Because one of the letters that have been put before the court is to the effect that Parliament makes lots of decisions, and some of the decisions involve third parties, and it isn't always still part of proceedings in Parliament. The example that's given is the parliamentary decision to build a new part of Parliament. So you have lots of building contracts and they go to litigation. Well, that's specifically dealt with in this report at page 246 within this section, Control by Parliament over its affairs. And you will see in the end of 246 that when Parliament is dealing with the outside world, it was necessary to, and what was created was the Parliamentary Corporate Bodies Act, so that the corporate officer can sign contracts on behalf of the House and sue or be sued. And there is a lengthy judgment on the topic, as you can see in the preceding paragraph, when there's reference, it doesn't matter, well, there was litigation based on a building contract with the House, the Harman case that you may or may not recall. So what we find in this part is a very interesting part, is 242, the precincts of Parliament are not a haven from the law. Well, that's not an issue. But then the need for a dividing line is 246 to 251, which we accept as an important part of the report. And you'll see that this is the passage where there's reference to the lines not being clear. 247, the dividing line between privileged and non-privileged activities of each House is not easy to define. Perhaps the nearest approach to a definition is that the area in which the courts ought not to intervene extend beyond proceedings in Parliament, but the privileged areas must be so closely and directly connected with proceedings in Parliament that intervention by the courts would be inconsistent with Parliament's sovereignty as a legislative and deliberative assembly. And there's reference to the McGuinness decision, and then 248. It follows that management functions relating to the provision of services in either House are only exceptionally subject to privilege. In particular, the activities of the House of Commons Commission, a statutory body, are not generally subject to privilege, nor are the management and administration of the House departments. The boundary is not tidy. Occasionally, management in both houses may deal with matters directly related to proceedings, which come within the scope of Article 9. For example, the members' pension fund of the House or Commons is regulated partly of the House of Commons is regulated partly by resolutions of the House. So too are members' salaries, and the appointment of additional members of the House of Commons Commission under Section 1(2)(b of the House of Commons Administration Act. These resolutions and orders are proceedings in Parliament, but their implementation is not. And really that's the line which we say is difficult to follow, that the resolutions that produce the management of pensions and salaries, particularly of allowances, we say is indistinguishable from the resolutions that create them. Well, I won't go over that in detail. You've got our submissions in writing. So, my Lord, what you have is the expressions of view in that report, still a question highlighted in 247, it's proceedings in Parliament or matters closely and directly connected with proceedings in Parliament, going back to paragraph 38. And it's important to get this right, because as I was saying earlier, if there is no Article 9 privilege or immunity, then the implementation, management, administration decisions can be, in fact must be capable of being questioned and impugned in court proceedings, essentially judicial review proceedings. And that would mean that individual fees office decisions could be challenged, as could other administrative decisions. We say in summary, the 99 joint report is broadly supportive of the former MP's arguments, but there is some assistance for the Crown, and overall the impact is neutral. Lord, those are the submissions that I wanted to make based on our written arguments, and I will now hand over to Mr. Fitzgerald unless there's anything I can assist you.
No, thank you very much. Mr. Knowles doesn't wish to add anything.
My Lord, and my Lady, there is a short speaking note, which I hope will shorten my submissions, which Your Lordship should. So the purpose of this is to deal with the alternative submission, that whether or not this conduct is covered by the concept of proceedings in Article 9, it is the subject of the exclusive jurisdiction of Parliament. And, my Lord and my Lady, there's ample authority that there is a wider principle of exclusive jurisdiction. We've set out just for the submissions in relation to this in the main grounds of appeal from paragraph 70 onwards, and the court can readily see at paragraph 72 the reference by the joint committee to the historical concept of exclusive cognizance or exclusive jurisdiction. And there, paragraph 72 set out the other main component of parliamentary privilege is still called by the antiquated name of exclusive cognizance or exclusive jurisdiction. Parliament must have sole control over all aspects of its own affairs to determine for itself what the procedure shall be, whether there has been a breach of its procedures, and what then should happen. This privilege is also of the fundamental importance, indeed acceptance by the executive and the courts of law, that Parliament has the right to make its own rules and has unquestioned authority over the procedures it employs, is of scarcely less importance than the right to freedom of speech. Both rights are essential elements in parliamentary independence. And so this...
So which joint committee is that? The just one?
That's the one you've just been looking at. It's volume 5, tab 49, and it's paragraph 13. And they deal with it further at paragraph 240. So there is a recognition that there are two alternative types of protection one founded on the interpretation of Article 9, which depends on whether this conduct comes within the context of proceedings in Parliament, and the other founded on the notion that there is a certain area of internal matters over which Parliament has exclusive jurisdiction, and Parliament should deal with it itself. My Lord, the only case in which this has arisen is the European Parliamentary case of Hutfield, where Mr. Justice Morland acceded to a submission of abuse on the grounds that a claim for expenses was within the exclusive cognizance of the European Parliament, and that it wasn't for the British police to start second-guessing the payment out of expenses. And just to trace that through, the Divisional Court reversed Mr. Justice Morland's decision, and then the House of Lords reversed the Divisional Court's decision on the basis that they had no jurisdiction, but stated in the course of the judgment that were this issue to arise again, the matter should be referred to the European Parliament, indicating that this was a serious issue, the issue of whether there was exclusive cognizance over parliamentary expenses in the European Parliament.
How do we distinguish jurisdiction from exclusive jurisdiction? Because it's clear that there are some areas which Parliament has jurisdiction over, which can also be prosecuted in court. For example, as the Joint Committee says in footnote 113, an assault is criminally prosecutable, but also would be considered by Parliament a serious contempt.
Yes.
So there's not everything within parliamentary jurisdiction is exclusive.
My Lord, yes. And our respectful submission is this, that if it's intimately connected with the discharge of parliamentary functions, and if it is, it's set out actually paragraph 1.2 of this speaking note, that the existence of Parliament's exclusive jurisdiction over certain types of conduct affecting Parliament has long been recognised, and I've given your Lordships, my Lady, the Joint Committee report. In the grounds of appeal, the applicants have traced the development of this wider concept of exclusive jurisdiction, and what we say is that, and perhaps at the end of 1.1, Parliament has exclusive jurisdiction over the conduct and misconduct in Parliament of MPs acting in their capacity as MPs, at least in their dealings with Parliament itself. I think the formulation that the Court of Appeal referred to was that any dealing a member has with the House in his capacity as a member. And that is designed to at least leave for concurrent jurisdiction the case of someone who punches another member on the floor of the House. Obviously, that would be a contempt of Parliament. It would be amenable to being dealt with by way of the disciplinary powers of Parliament, or alternatively, although it might be something overreaction, it could be dealt with by way of the police being called in. But those would be that's a concurrent case. But we do respectfully submit that's because that's got nothing to do with the relationship of the Member of Parliament to Parliament itself. It doesn't concern dealings between the Member of Parliament as a parliamentarian with Parliament. And my Lord, that's how we seek to draw the distinction. So our further...
I'm sorry, I'm going to say you lost me. Why, if you punch another member in the House in the middle of a debate, it has nothing to do with Parliament?
Well, you're not doing it qua parliamentarian. You're not saying this is one of my functions as MP is to punch you in the face. What you're doing it as an irate human being, hitting another human being. You don't purport to be doing it in your function as a Member of Parliament.
You might want to shut him up.
Well, my Lord, my Lord, you might, but it's not in your capacity as an MP or in your dealings with Parliament itself. My Lord, that's the distinction we draw. And indeed, when one looks at Bradlaugh and Gossett, the examples that Mr. Justice Stephen given, the context in which he gives it, is the context of interpersonal violence. My Lord Phillips has already referred to the fact that the question was it excessive force used by the officer in Bradlaugh and Gossett? So that was a question of violence. Where the question is the honesty or otherwise of a submission made in your capacity as a Member of Parliament to another Member of Parliament, to Parliament itself, then we respectfully submit that is within the exclusive jurisdiction of Parliament, because it has the power to discipline members the exclusive power to discipline members for their dealings with Parliament itself, in their capacity as MPs. What I would wish to do is to take the court to the key historic cases which refer to this concept of exclusive jurisdiction, to indicate that one has to give some meaning to this concept of exclusive jurisdiction, and then to seek to define the contours of it, and why it certainly includes this alleged misconduct by these MPs. And so we invoke the wider principle of exclusive jurisdiction as set out 1.1. The wider principle does not depend on the meaning of the word proceedings, but it does depend on identifying the ambit of the exclusive jurisdiction of Parliament to discipline its own members for misconduct in relation to internal matters. And it is submitted that Parliament has exclusive jurisdiction over the conduct and misconduct of MPs acting in their capacity as MPs.
Is this a privilege of Parliament? I'm sort of lost how it works.
Right.
How the bits fit together.
It's described as exclusive. Can I just show your lordship the authorities where it's described? It's a privilege in the sense that Parliament is given this, or is recognised to have this exclusive competence.
That's really what I was getting at.
Yes. So in that sense, I'm so sorry.
No, please.
Yes.
Continue.
So in that concept, it is something. It is a power, an exclusive power, recognised to reside in Parliament by the courts and by the executive.
They're non-justiciable in the courts. Is that the point?
Yeah, my lord. Yeah. That's absolutely right, and that it's non-justiciable, and it's.
Is it because the ordinary courts recognise Parliament as being the court which deals with these matters?
That obviously was the original
thought.
Yeah, the original thought was the High Court of Parliament deals with these matters itself and disciplines its own members for their own misconduct. And it may well be that at one stage that might have included all forms of misbehaviour, but I would certainly accept that interpersonal violence has, for reasons which we can see as principle, been recognised to be in a different category. But we respectfully submit that the act of submitting a claim form for expenses intimately connected with the discharge of your functions is an act which is an act you do in your capacity as a parliamentarian and in no other capacity. And it cannot make a difference to say, well, if you do it dishonestly, it loses that power to attract the exclusive jurisdiction, because that would be just the same as saying that in the case of an act of state or an official act that attracts immunity, that if you do it for your own gratification, it ceases to be an official act. And the courts have repeatedly said that that's not the case.
Well, do you submit then that every act that you do in your capacity as a parliamentarian falls within the exclusive jurisdiction of Parliament?
At least in their dealings with Parliament itself. So any dealings a member has with the House in his capacity as a member. So it's got to be the dealings a member has with the House in his capacity as a member of Parliament. And
if someone attacks another from a political motivation, because, as my Lord Clark has said, he wishes to silence his opponent, or he wishes to advance a particular political purpose, is he doing that in his capacity as a parliamentarian?
No, my Lord, we say...
Why not?
Because, my Lord, we submit that there are ways in which it's acknowledged that you can participate in debates, and they don't include punching somebody else. Speech is the acknowledged manner of participating in debates. My Lord, I do accept that in the case of Sir John Eliot, the holding of the Speaker down was for a political purpose. There's no doubt about it. There was a very good reason to stop him adjourning the House and keeping him to his chair.
Well, if you assault the Speaker in order to prevent him adjourning the House, is that within the exclusive jurisdiction of Parliament?
No, my Lord, we say any dealing a member has with the House in his capacity as a member, that is not a dealing you have with the House in your capacity as a member. And we say that in the case of Sir John Eliot, although it wasn't finally determined, it has generally been accepted that the assault fell into a different category than the speech. And indeed, as my learned friend Mr. Fleming has indicated, the ratio of the decision in Sir John Eliot's case was not that the assault was within the exclusive jurisdiction, but that it shouldn't have been muddled up with speech, which was within the exclusive jurisdiction. And that was the vice.
This is some distinction between the words and the acts, so that there's no distinction between honest and dishonest words, but there's a distinction between words and acts.
My Lord, there certainly is, but what we would say is if the acts are acts of violence, they're not covered by the exclusive jurisdiction.
So if you physically intimidate someone by gross verbal abuse, that's not covered?
My Lord, no, and indeed it would be very dangerous if one did go down that path, because then Ian Paisley ranting in the chamber would be regularly. He would be calling in the police every 5 minutes. But you can't have a situation in which. I'm sorry, my Lord. I'm just trying to think of an example where.
Yes, but the example seems to be at odds with your answer.
I'm sorry.
If you seek to intimidate someone by gross verbal abuse, but don't engage in physical confrontation, is that covered? Is that part of the exclusive jurisdiction of the House or not?
Well, my Lord, the reason there is an absolute immunity for words spoken, and that's not altered by the motive in which you speak them. And therefore, we would say, whatever you say, however you say it, there is an absolute immunity because of Article 9.
Even if it would amount to the tort of assault?
Yes, my Lord. We would say it matters not how you speak, with what motive you speak, with what effect you speak. Because, well, my Lord, just a very simple example that my learned friend Mr. Fleming has given, a speech which is an incitement to racial hatred, or a speech which is an incitement to murder, given in the House of Commons, is exempt. And that's why the Court of Appeal's analysis of ordinary crimes are justiciable is simply too simplistic. Because the line is, if it's something uttered, it doesn't matter how you utter it, with what motive you utter it, it's a speech act, it is exempt. And we respectfully submit that, my Lord, I hope I wasn't intending to be flippant in
No.
What I'm saying is that that's where we draw the line.
I wonder if you can go quite that far. I mean, if taking up Lord Clark's suggestion, supposing you said to someone, to the Speaker, if you put that gavel down now, I'll ensure that you're beaten up outside. You say that would be immune?
Yes, my Lord, I do. It's important that one makes no concessions on speech at all, because they shall not be questioned in any other House. My Lord, otherwise one starts to say, well, he said it in an intimidating way, so the police can start interesting themselves in the content and the manner and the mode of speech in the House of Commons. That would undermine it. And well, we say it is an absolute immunity. But we of course say in this context that the written communication to an officer of Parliament acting on behalf of Parliament attracts the exclusive jurisdiction. We of course, but both of us have submitted, both councils have submitted that it's proceedings, but in any event we submit that it attracts the exclusive jurisdiction. Well, I hope it will be of assistance if I just take you briefly through the historical references to exclusive jurisdiction. They are set out in more detail in the grounds, but if I can go to 1.3, as set out in paragraph 77 of the grounds, Blackstone recognised Parliament's exclusive jurisdiction over its internal matters in the following terms, and this is from volume 4, tab 39. The whole of the law and custom of Parliament has its origins from this one maxim, that whatever matter may arise concerning either Houses of Parliament ought to be examined, discussed, and adjudged in that House to which it relates, and not elsewhere. Now, though some of the statements made by Blackstone in his commentary on this issue have been later qualified, we respectfully submit that that is a correct statement still. And then going from there...
Mr. Fitzgerald, if that's right, and if indeed your case is right, I think logically the police had no business ever investigating any of these expenses claims.
Well, my Lord, that actually is a logical corollary, my Lord, I accept that, yes.
And that is indeed your case.
Yes, that's absolutely...
whatever deceit, whatever forgery, whatever, they simply...
Yes.
They had no business looking into it at all.
No, my Lord, and indeed, the whole point of the protection is a protection from the chilling effect that the fear of investigation, questioning, prosecution, and trial would have. But the first of those steps, of course, could very well be the most intrusive. The idea that someone says he's written something untrue in an application. Call in the police. And where does it end in terms of protection of Parliament from questioning on every aspect of internal matters?
Well, is it really based on chilling effect, or is it not simply a reflection of the supremacy of Parliament?
Well, my Lord, one does see in all the earlier cases, indeed, Blackstone actually says that the rationale of this rule is to prevent oppression by the executive. It's to protect Parliament from oppression by the executive. Now, of course, we now say, well, there was a particular historical context, but we do submit that still holds good, that's one of the rationales. The other rationales are that there should be a speedy, consistent adjudication by the body which is the appropriate body to look into these matters, that's to say Parliament itself, of what in fact would constitute a contempt of Parliament, rather than having this selective process where some are looked into by the police and some are looked into by Parliament, although the dividing line is pretty difficult to tell in this case, where you've got, well, your Lordships will have seen in the newspapers that some people are being investigated by Parliament itself, and it's said that they get facing the risk of censure for conduct very similar to the conduct alleged against these applicants. And therefore you can't have this, well, we'll let the police have these, but we'll deal with these ourselves sort of approach. That is our respectful submission. And when the matter of Huckfield was before the House of Lords many years ago, Lord Templeman observed that the reason why one needs to have a special sensitivity to the protection of Parliament, particularly in Europe, was because of the particular historical experience of oppressive executives in Italy and Germany taking steps against members of Parliament. So we do say there is a continuing rationale. Blackstone identified it to protect against executive excess, but there is the risk of a chilling effect. My Lords, my Lady, can I take you to Stockdale and Hansard, which we've summarised at 1.4. That involves publication in Hansard of a libel about Stockdale's anatomy. His anatomy book had found its way into certain prison libraries, and it was said to be pornographic.
One of Stockdale's dirty books.
Yes, that's right. That was what was said, and in fact, it was just information. And there was, there had been a libel about that published by order of the House of Commons, and it was said that application didn't. That the immunity didn't apply in relation to a publication by Hansard of a book criticising Stockdale. But Mr. Justice Coleridge made clear that the principle of the exclusive jurisdiction of Parliament predated Article 9 of the Bill of Rights and was independent of it. And one has there, it's at volume 3, tab 32, page 1199, but we've set out the key passage. In point of reasoning, it needed not the authoritative declaration of the Bill of Rights to protect the freedom of speech, the debates or the proceedings in Parliament from impeachment or question in any place out of Parliament, and the House should have exclusive jurisdiction to regulate the course of its own proceedings and animadvert upon any conduct in violation of its own rules. So we do rely on those words, and animadvert upon any conduct in violation of its own rules or derogation from its dignity, and it stands upon the clear-cut grounds of necessity.
Trouble with that is it doesn't tell you how far the common law rule is wider than, quote, freedom of speech, debates or proceedings of Parliament. No. We know it doesn't extend to punching you on the nose, but so this passage doesn't really help, does it?
No, my Lord, I think what it assists in is that there is a concept which is independent of Article 9, so that even if Article 9 didn't exist, we could be making the submissions I'm making at any rate to the court.
And presumably Article 9 only exists because Parliament thought that the scope of its privilege had been misimplied before that. Is that right?
Well, yes, but the Bill of Rights in a sense is declaratory, of course, my Lord.
Yes.
The principle of no cruel and unusual punishments was theoretically available in the common law already, but they wrote it in there because this was a new... Right. The extent to which the Bill of Rights is merely declaratory of the common law rather than innovation is obviously a matter of historical debate. But some of the things that are included in there are merely reaffirming what legal historians would say were already there.
Already there.
Yeah. So my Lord, but certainly the fact that it is there gives an absolute boundary that if it's proceedings, that's it, and no wider issues of is this a good thing or not arise. It's an absolute immunity.
So the only relevance from our point of view is to work out what the wider principle might be, because if the case comes within the Bill of Rights, that's the end of it.
Yes.
So we're only really interested, aren't we, in finding out to what extent it's wider than it would be under the Bill of Rights.
I accept that, my Lord. All I can respectfully submit to you is that if it's not proceedings, then it certainly is covered by this notion of exclusive cognizance. But my Lord, I accept that the two are very closely connected.
This case itself is not very helpful to your position, is it? Because this appears to have been a case where Hansard was printed and published by order of the Speaker with members concurring in the resolutions and yet not protected as, I suppose, you would say it was published for the public.
Yes, it's the Publishers Act of publishing it that rendered it susceptible to general law. My Lord, that's our respectful submission. If I could then take the court to Bradlaugh and Gossett, Lord Coleridge in that case recognised that there was a limit to reliance on parliamentary privilege to oust the general law. And that, of course, arose out of the power of Parliament to penalise Bradlaugh by not permitting him to take his seat, or indeed not permitting him to take the oath, because I think the suggestion was that he'd raced through it discourteously on an earlier occasion. But Lord Coleridge nonetheless emphasised the existence of an exclusive jurisdiction in Parliament to impose discipline on its own members for internal misconduct with the words, "What is said or done within the walls of Parliament cannot be inquired into in a court of law." On this point, all the judges in the two great cases are agreed and are emphatic. The jurisdiction of the House over their own members, their right to impose discipline within their walls, is absolute and exclusive. Mr. Justice Stephen, although he made the statement about ordinary crimes, he upheld that principle, and we've given the court the references at pages 278 to 280. And that was a case in which Parliament's exclusive jurisdiction was in fact upheld in the face of a powerful argument that an injustice had been done. That's to say that the idea that there is some exclusive area which the courts can't go into, even if they regard the fact that they can't supervise what happened as leading to a potential injustice. If I can take the court next at 1.6, that there have been recent cases which have re-emphasised the concept of an exclusive jurisdiction. Preble, in the Privy Council, my Lord Kerr's judgment in the Guinness case, and the House of Lords in the case of Hamilton and El Fayed. And if I could just take the court just to those key passages. Preble was the New Zealand television case, which involved a minister, and the allegation by the television station was that the minister had lied to Parliament, that the government did not intend to sell certain state assets, but it was held that that allegation of lying to Parliament simply could not be investigated. Lord Brown Wilkinson recognised that Article 9 was merely one manifestation of a wider principle, namely that the courts and Parliament are both astute to recognise their respective constitutional roles. And if I take the court very shortly, Volume 2, at tab 20, to the passage, I think my learned friend did take you through some passage that one sees, he sets out at page 332D that in addition to Article 9 itself, there is a long line of authority which supports a wider principle, of which Article 9 is merely one manifestation, viz. That the courts and Parliament are both astute to recognise their respective constitutional roles. So far as the courts are concerned, they will not allow any challenge to be made to what is said or done within the walls of Parliament in performance of its legislative functions and protection of its established privileges. So that the limitation there is that it must be in performance of its legislative functions and protection of its established privileges. And then there's a citation of Burlett, Abbott, Stockdale, Bradlaugh, Pickett, and then the quotation from Blackstone that I've taken the court already too. And I think that the court was taken to page 334D, but I should just take you again to that. Misleading the House is a contempt of the House, punishable by the House. If a court were also to be permitted to decide whether or not a member or witness has misled the House, there would be a serious risk of conflicting decisions on the issue. We do respectfully submit that misleading the House there is not confined to conduct on the floor of the House, that's to say, in debate in the House itself, but extends to misleading statements in submissions to the House and indeed misleading statements.
That's also about freedom of speech, isn't it?
Yes, but the concept that it goes back to is the concept of an exclusive jurisdiction as well as Article 9, because one sees that because it's a contempt of the House, there is that engages the exclusive jurisdiction of the House to deal with it. So my Lord, it's both, and indeed Lord Brown Wilkinson appears to be placing greater emphasis on the wider jurisdiction there. I appreciate that I must deal with my Lord Clark's point that what does it add, but for the moment I just wish to establish that there is this independent jurisdiction, which, irrespective of whether it comes within the term proceedings, says that there's certain types of conduct over which Parliament has the exclusive power to impose sanctions. So we do rely on 334D there. Because
So, I mean, where's the scope for conflicting decisions here? Why is that a serious risk? How does that work?
well, I suppose it could arise in this way, were there to be an inquiry by the police and said there's absolutely nothing in this case, and then Parliament inquires and says we think there is something in this case. We think you've been dishonest, or the other way around, that there is a conviction, and then Parliament deals with it in its disciplinary function and says that was completely wrong. And we have our own separate jurisdiction. We're not going to discipline you because we think this was what everybody else was doing at the time, and entirely within the established practice and usage.
Although with the punch, it's accepted that you can have that risk, because there are areas where the jurisdiction is concurrent or is coextensive.
Well, my lord, yes. What I don't think I can do at this, I'm not going to try and go back on the statement by Mr. Justice Stephen, which has been approved subsequently, that there are areas of ordinary crime which are susceptible to the court's jurisdiction. But my lord,
My only point is you can have a case
Yes.
which is accepted to be susceptible to the court's jurisdiction,
yes.
but where the underlying facts would also form the basis of disciplinary proceedings in the House.
I do accept that, my lord, but we say one where it's a statement to Parliament. That's peculiarly within Parliament's own.
I understand that. I'm only on your point about the possibility of differing verdicts.
Well, I accept that. We say one should keep the possibility of differing verdicts to the minimum. And if there is that possibility in relation to, I think what happens, if you swing the mace in Parliament, they might decide to deal with it domestically, disciplinary-wise, or they might refer it out to the police. And it's quite right, as your lordship observes, there could be conflicting decisions. But we say it's rather different when, qua parliamentarian, you are making a statement to Parliament, and Parliament says you haven't misled us, and the courts say you have.
I mean, you can't talk about disciplinary. Is it disciplinary?
Well, no, I'm sorry, my lord. I'm using that as a shorthand. No, it's a power of what is in fact the High Court of Parliament to punish for contempt.
For contempt?
Yes,
Yeah.
and it's a power to, and they obviously have to adapt their procedures. But my lord, it isn't correct to describe it as, because it isn't like the kind of the rugby situation where gouging normally gets dealt with internally, but then sometimes they send it out to the police. This is where there is a court, a high court, dealing with you for contempt, and centuries of cases have said it's appropriate that Parliament should have exclusive jurisdiction over certain types of misconduct which involve the relationship of the parliamentarian to Parliament itself. And my lord, we say you can't just, as it were, dismiss the repeated use of the word exclusive. In the old cases and in the new cases, it's got to have some meaning. And the underlying rationale appears to be that there are certain internal matters which are for Parliament itself to apply the sanctions in relation to. McGuinness is the case at Volume 2, Tab 18, where my Lord Carr, in his capacity as a judge hearing a judicial review application, dealt with the question of whether the Speaker's announcement that Mr McGuinness would not be allowed to enjoy the facilities of the House of Commons because he had refused to take the oath of allegiance. And my Lord Kerr, as he then was, found it unnecessary to determine whether the Speaker's decision fell within the scope of the expression proceedings in Parliament, so as to benefit from the immunity under Article 9, although I think the indication was that my Lord would have been disposed to so find if necessary. But if I could just take the court to find to page 2, so it's Volume 2, Tab 18, and one has the citation at page 5 at the top, the citation from Blackstone, and the citation in an earlier Al-Fayed case from Mr. Justice Sedley. Article 9 is, I think, better viewed as Lord Brown Wilkinson views it as part of a wider principle forming a part of the historic constitutional settlement arrived towards the end of the 17th century. And then one has Erskine May talking about the concept of proceedings. And then if I can take the court on to page 7, about 4 paragraphs down, the extent of parliamentary privilege has not been precisely defined. It may be unwise to attempt too close a definition of it. I'm satisfied, however, that whatever its ambit, this action by the Speaker falls clearly within it. It may, as counsel submitted, that the Speaker does not enjoy an automatic ex officio immunity. It may also be that the announcement of these measures in the House may not be sufficient per se to attract parliamentary privilege, but the combination of characteristics which the Speaker's decision possesses is sufficient to distinguish it as a measure to which parliamentary privilege must attach. I should take the court to page 6. Perhaps at the top, 2 points should be noted from these passages. Firstly, a member may be engaged in proceedings in Parliament outside the chamber, thus attendance at a private party meeting to discuss parliamentary matters in the precinct of the House of Commons was deemed to be a proceeding in Parliament. Secondly, whether a particular matter falls within the definition of proceedings in Parliament will normally be a matter for the House of Parliament to decide. In view of these considerations, the Court should be slow to reject a claim by the Speaker that an action taken by her to regulate the availability of facilities is a proceeding in Parliament. This is particularly so because the Speaker, in extending the restriction on service and accommodation, is acting as a delegate of the House. And on 23rd March, the Prime Minister made a statement to the House that Her Majesty the Queen had agreed that the control, use and occupation of the Palace of Westminster and its precincts should be permanently enjoyed by the House of Parliament. The Government decided that control of the accommodation and services at its precincts should be vested in the Speaker on behalf of the House. And then, in extending the restrictions on facilities and services, the Speaker was thus acting on behalf of the House. She was dealing with a matter which affects members' access to services relating to their duties as MPs. Those services are available to them because they are members of Parliament. For these reasons, were it necessary for me to do so, I would have held that her decision to introduce these restrictions was a proceeding in Parliament, or rather that her assertion that it was so could not be challenged by way of judicial review. In this context, I should note the concession of counsel for the applicant. The provision of these services and facilities was ancillary to the activities of members in the chamber itself. And then going on from there, he submitted, however, that if there was no evidence that they had a direct or intimate connection with those activities and that they had not been shown to be essential for the proper discharge of members' core functions as legislators, the Council was unable to point to any authority to support the claim that to qualify as a proceeding in Parliament, an activity outside the chamber had to be shown to be essential to the discharge of functions within it. The Speaker's announcement in the House of Commons of action taken by her on behalf of the House to regulate the use by members of services which are ancillary to their work within the chamber must therefore be considered to be a proceeding in Parliament and immune from judicial intervention. As I've said, however, it is unnecessary for me to reach a final conclusion on this because I am quite satisfied that whether it qualifies as a proceeding in Parliament or not, the Speaker's action lies squarely within the realm of internal arrangements of the House of Commons and is not amenable to judicial review. Control of its own internal arrangements has long been recognised as falling uniquely within Parliament's domain and superintendence from which the Court's intervention is excluded. And we do rely on that both it being proceedings in Parliament and the concept of control over internal arrangements being uniquely within Parliament's domain and superintendence, which is effectively the concept of the exclusive jurisdiction, perhaps described in more modern terms.
I think one must be a little cautious. The idea that merely because the services are available to them as members of Parliament and the Speaker was dealing with a matter affecting members' access to services relating to their duties as MP, if I slip a forged £5 note to the pay for my meal in the Lord's cafeteria, is that I've no doubt that there is the refreshments committee sets the amounts payable and so on and runs the cafeteria, but am I really taking part in a proceeding in Parliament?
Well, of course, in this case, it was the decision of the speaker herself. And that was the basis that it was the speaker acting acting in her capacity as the representative of the House of Commons. But we do submit that the concept of internal arrangements, if Well, you mean, in other words, just because it's necessary for my function?
Yes.
Well, again, our test would be satisfied in the sense that it's ancillary to the performance of one's functions, and it involves the conduct of these MPs, their dealings with Parliament itself, and therefore attracts the exclusive jurisdiction of Parliament. But, my Lord, as to whether when it does deal with control of its own internal arrangements, has long been recognised as falling uniquely in Parliament's domain and superintendence, we do submit that principle we can rely on and applies to this case. That's something that Parliament, its own internal arrangements, could aptly describe exactly what's happening here.
If one's poisoned in the member's dining room or trips over a hazard in the carpet in the floor and suffers an injury, what redress does one have?
I think there may be some guidance on that in the joint committee, but in other words, can you do occupier's liability?
Yes.
Yeah. I think, my Lord, I think that is a matter that is addressed by the joint committee, and I think their conclusion was that the position should be made clear that there should be a right to sue, but it wasn't clear.
I have a recollection that this was very controversial at one time,
yeah.
and it was decided that it would be a very bad example to give to the public if you didn't apply the same kind of law within Parliament and so on. And that, so I think that must have been all regulated, actually.
It was A.P. Herbert's case, wasn't it?
That comes after the A.P. Herbert case.
Yes, well, we do have the A.P. Herbert case available if your lordship, my lady, would wish to see it. But of course, I mean, that actually is a case where the members of the kitchen committee and the bar manager couldn't be prosecuted for breach of the licensing rules. And again, it's somewhat loosely reasoned, but the Chief Justice, Lord Hewitt, page 602, does encapsulate the concept of there being an exclusive area from which the jurisdiction of the courts is ousted. There certainly is an answer to the notion that ordinary crimes, because this was an ordinary crime if the House of Commons was to be treated as any other place, a crime of violating licensing rules. And the court will see that at page 602, Lord Hewitt said, I'm satisfied these rules should be discharged. In my opinion, the magistrates came to a correct conclusion, sufficient materials that were before him. And one has, halfway down here, as it seems to me, the magistrate was entitled to say on the materials before him that in the matters complained of, the House of Commons was acting collectively in a manner which fell within the area of the internal affairs of the House. And that being so, any tribunal might well feel on the authorities an invincible reluctance to interfere. To take the opposite course might conceivably be somewhat, and then the point about it going to the House of Lords and them overruling a decision of the House of Commons. But we do respectfully submit that though there's the language of reluctance to interfere, there's also the language of invincible, and therefore it is that it simply, one should have no jurisdiction in the courts to deal with a matter of that sort.
You have that in the bundle, something?
It is.
On the side table.
No, we've just
it's just to write.
We've just added. It's page 602.
Yeah, thank you.
And then finally,
I think it's very questionable whether it was rightly decided.
well, my lord, what we Well, my Lord, we would submit it was rightly decided, but we don't need to depend on that because what we're dealing with is the dealings between Parliament itself and a parliamentarian qua MP. And then in Hamilton and Al Fayed, that concerned a defamation claim by a former MP, Mr. Hamilton, who'd waived his parliamentary privilege. And in that case, Lord Brown Wilkinson first cited and reaffirmed what he'd said in Preble about the fact that parliamentary privilege was based on a wider principle than that contained in the words of Article 9 itself. And that's the principle that the courts and Parliament are both astute to recognise their respective constitutional roles. And then he went on to state this, and perhaps I can just draw attention of the court to the key underlined passage: to mislead Parliament is itself a breach of the Code of Parliamentary Behaviour and liable to be disciplined in Parliament. For the courts to entertain a question whether Parliament has been deliberately misled would be for the courts to trespass within the area in which Parliament has exclusive jurisdiction. And we submit that is not confined, again, to statements on the floor of the House and cannot, for any reason of logic or principle, be confined in that way. And so we say, respectfully, that the repeated reaffirmations of the principle that Parliament has an exclusive jurisdiction over certain internal matters cannot be dismissed lightly, nor can the repeated reaffirmation that Parliament has an exclusive jurisdiction be transformed into a statement that Parliament merely has a concurrent jurisdiction with the ordinary courts in these areas. And then we submit that the applicants or the appellants' alleged conduct comes within the scope of the exclusive jurisdiction, repeatedly recognised by the courts for the following three reasons. Firstly, because it arises from the administration of a scheme created by Parliament, regulated by Parliament, and policed by Parliament, which has its own recognised power to punish members for false claims. And that's really dealt with at paragraph 50 and 58 of the grounds in more detail. And I adopt all that my learned friend Mr. Fleming has said about the nature of that internal scheme. Secondly, the alleged misconduct takes the form of making misleading statements to Parliament. Such conduct is itself a breach of the Code of Parliamentary Behaviour and liable to be disciplined in Parliament. And that's Lord Brown Wilkinson in Hamilton and Al Fayed. And then for the reasons set out in more detail in paragraph 88 of the grounds, the fact the statement is not made in the course of debates is irrelevant in the context of this wider principle. It doesn't have to be on the floor of the House. And the De Oliveira case that my learned friend, the Attorney General of Ceylon, De Oliveira, makes it clear that we've moved beyond the floor of the House in dealing with this notion of exclusive jurisdiction.
Except that the Joint Committee made clear that it didn't think that ought to be the subject of privilege, did it? In that case, it was, do I remember rightly, it was statements made by an MP to a minister.
Yes.
And the Joint Committee discusses that at some length and says that they oughtn't to be privileged.
Well, yes. My Lord, we would prefer the Privy Council's decision.
But anyway, you avoid it by saying that we're dealing here with statements made to other MPs rather than to a minister outside Parliament.
Made to Parliament.
Made to Parliament.
Made to Parliament itself, yes. Yes. But I think that it's uncontroversial what De Oliveira says, that we've moved beyond it having to be on the floor of the House, even if it went too far in your lordship's in the view of the Joint Committee. Thirdly, Parliament has its own power and procedures for dealing with allegations of this kind, and the exclusive right of Parliament to punish for misconduct in relation to internal parliamentary matters, recognised in Stockdale and Bradlaugh, the ratio of Mr. Justice Morland's judgment in Hutfield. Can I just give the court the reference to the key passage of Mr. Justice Morland's judgment? It's contained in the Divisional Court's review of his judgment at volume 3, tab 28, page 696H, 697B. And it was really the European Parliament's got its own code, its own disciplinary code for dealing with false expenses claims, and therefore they should be left to deal with it and not have the British police and British prosecutors coming in on an issue of that nature.
What powers has Parliament got to deal with these cases?
Well, my Lord, we deal with that in the first part of the case, of the grounds of appeal. They have a power of suspension there is some doubt as to whether they still have a power to fine.
If you cease to be a member of Parliament, suspension is not
no,
sanction.
no, I accept that, my Lord. And there is a theoretical power of imprisonment which has not been used, I think, since 1880, but it remains a power that is referred to, and that is it's analysed in the early parts of the grounds of appeal, and it's also dealt with in Halsbury, which is I think it's in volume 5. Perhaps somebody can check for me. There's an analysis of Parliament's powers to punish for contempt in Halsbury's. But of course, if it hadn't been for all this prosecution, the matter could have been dealt with swiftly and appropriately, and investigated and led to a conclusion, at least a year ago, anyway. We do make the point at 1.12, just asking, as it were, what's the point of having an exclusive jurisdiction? That there is some point to the recognition of an exclusive jurisdiction. The alternative is the assumption by the executive, in the form of the police and prosecuting authorities, of the power to investigate, interrogate, prosecute and try members of Parliament in relation to the operation of an internal parliamentary scheme considered necessary for the discharge of their functions, and about the truthfulness or otherwise of statements made to Parliament by MPs in connection with that scheme. We submit that there is a clear justification for ensuring that these matters are dealt with swiftly, internally, consistently, with minimum disruption of the parliamentary process, and that there be no suspicion of inappropriate executive or external interference with members of the legislature. My Lord Collins referred to the judgment in the case, the American Supreme Court judgment. We do just refer the court to the dissenting judgment of Mr. Justice Brennan at volume 4, tab 38. Can I just give you the reference, pages 534 to 535, where he makes the point about the disruption by allegations which may be false and may be politically motivated of the legislature and legislators in the performance of their vital constitutional functions. And it's, as my learned friend Mr. Fleming said, it's the risk and the threat of that, rather than just simply saying, assuming the dishonesty and saying we can't possibly have dishonest conduct being exempted. The question is, assuming it's not dishonest, what is the consequence of having allegations of this sort constantly the subject of investigation, interrogation and prosecution? Then just dealing with the Court of Appeal's judgment, I think I can take this very shortly, my Lord, because many of these points have been dealt with by my learned friend. The three cardinal bases for rejecting the exclusive jurisdiction that we discern in the Court of Appeal's judgment are, firstly, that there was no authority for the proposition that an ordinary crime committed in the House of Commons would be withdrawn from the ordinary course of criminal justice. That's paragraphs 30, 32, 36 and 39. Secondly, that any exclusive jurisdiction was confined to cases where the matters occurring within the walls of Parliament were essential to the performance of Parliament's functions. That's paragraphs 32 and 76. And thirdly, that if Parliament were concerned that these prosecutions would breach privilege or Parliament's exclusive jurisdiction, it would have taken formal steps to intervene. That's paragraph 7, relied on by the prosecution. As to the exemption of ordinary crimes, your Lordships and my Lady have the point that the Court of Appeal found much of its reasoning on the proposition of Mr. Justice Stephen and Bradlaugh that there's no known authority for the proposition that an ordinary crime committed in the House of Commons would be withdrawn from the ordinary course of criminal justice. Well, of course, we accept that the physical location in the House of Commons does not confer exclusive jurisdiction. So murder or rape in the corridors of the House of Commons could be prosecuted as could theft by an MP from another's pocket. The remarks of Mr. Justice Stephen were made in the specific context of ordinary crimes of violence, because he was dealing with the use of force by the Sergeant at Arms, and then he goes on to deal with the Elliot case. and it's easier to make a categorical statement that ordinary crimes do not fall within the ambit of Parliament's exclusive jurisdiction when dealing with a crime of interpersonal violence. But we submit the position is not so clear-cut, where the alleged conduct involves a misleading statement allegedly made by an MP to Parliament or to an official authorised to act on Parliament's behalf. And that is because if the statement is made in the course of an MP's essential dealings with Parliament, which would ordinarily be subject to Parliament's exclusive jurisdiction, then the fact that the statement may be dishonest cannot alter the jurisdictional position. I think all the courts have been agreed that you can't, just by saying, well, it cannot have been the intention that dishonesty be exempted, determine the issue either of exclusive jurisdiction or indeed of the meaning of the word proceedings. One has to assume that if there is an exclusive jurisdiction to deal with a particular type of conduct, it doesn't matter whether it's honest or dishonest. And so we submit that the position is as follows, that if conduct which would otherwise have the necessary constituents making it susceptible to ordinary prosecution is committed by way of allegedly criminal, fraudulent or misleading statements to Parliament, then it will be within the exclusive jurisdiction of Parliament. So a speech that incites to murder, racial hatred, or a statement to a committee with the same offensive characteristics will nonetheless be exempt from prosecution. And I think my learned friend took you to the ex parte Wasson case. A conspiracy to obstruct the course of justice by a false statement will not be indictable. And you've already seen the court's already seen the A.P. Herbert case, which we submit is consistent with that approach. To the extent that the court finds it of assistance. And our basic conclusion on ordinary crime is that it means no more than an allegation of misconduct that is not within the exclusive jurisdiction of Parliament. But misconduct that would constitute a crime but for its parliamentary context is exempt from prosecution when it is intimately connected with the discharge of parliamentary functions and involves a member of Parliament's dealings with Parliament itself. And motive does not turn it, as to say, a bad motive does not turn it into something that is susceptible to the jurisdiction of the ordinary courts. The Court of Appeal then relied on the need for conduct to be related to core functions. To a great extent, my learned friend has dealt with the reply that we make to that point. But can I just indicate that the Court of Appeal took the view that within its walls had to be interpreted metaphorically and not literally. We accept that it's not literally everything within its walls because that wouldn't cover rape, murder and other serious interpersonal violence within the walls of Parliament. But the principle of exclusive jurisdiction the Court of Appeal held only applied when the matters occurring within the walls were essential to the performance of Parliament's function. That's the basis on which they held that expenses claims were not exempt from ordinary prosecution was it had nothing to do with freedom of speech and didn't involve the exercise of the MP's real or essential functions or his or her core activities. Our submission at 4.2 is that the process of making a claim under the ACA scheme is part of a process that's deemed by Parliament itself to be necessary to the discharge of an MP's legislative functions. And we set that out at paragraphs 50 to 58 of the grounds of appeal. The declaration in the claim form is to the effect that expenses were incurred wholly, exclusively and necessarily to enable me to stay overnight away from my only or main home for the purposes of performing my duties. So the representation is about your duties, it's to Parliament, and it's in the context of a scheme devised in order to enable them to discharge their functions as legislators. And for all those reasons, we submit that it is intimately connected with their function as MPs and does involve their dealings with Parliament itself. And for those reasons, we submit that the declaration that an MP makes to Parliament in connection with the MP's core functions, it is a declaration made to Parliament. in connection with the MP's core functions. And that's sufficient to attract the exclusive jurisdiction. My Lord, does the court rise at this
Yes,
stage?
we will rise now.
We're missing the next page.
I'm so sorry.
We're missing the next page.
Oh, I'm
Page
so
14.
sorry. Oh, okay. Well, that will be.
Very convenient.
I'm so sorry. That will be just to indicate that deals with the position of Parliament. Part 5. My learned friend indicated that I would deal briefly with what were said to be the indications that Parliament, through its relevant committees, has expressly stated that it didn't want to assert privilege. And what we do in the last pages from 15 onwards is just simply to analyse the various indications relied on by the prosecution and the Court of Appeal. Although it won't take long.